Hello and welcome to this, the fourth and final session in this short course on the paleography of the mid-17th century records of the Manor Court of Conisbrough. My name is Charles Kelham and I'm the Borough Archivist of Doncaster. In this session, the aim is, firstly, to become familiar with the type of business that came before the court at this period, then to learn something about the procedure followed by the court, and lastly, by putting into practice some of the subjects covered in the earlier sessions, to be able to read a sample passage from the roll. As before, the resources you may wish to have handy are speakers or headphone, paper, pen and a magnifying glass. Half the battle in paleography is being able to establish beforehand what sort of document you're looking at. Taken in broad terms, virtually all documentation can be classified as a letter, a list or a narrative. A letter is something that informs or instructs specific individuals, or informs or instructs everyone who sees it. A list can, for example, be an inventory, or inventory if you prefer, or a financial account, or a list of names of people or places. A narrative is an account of things that have taken place. Now there are subcategories, and there is overlap between the three, but these are the essential types. Court records, such as those of the Manor of Conisbrough, are a narrative account of proceedings in the court. Establishing this gives us a clue at the outset as to the subject matter and terms and expressions we might expect to encounter in them. What we also need to bear in mind, though, is that their focus at this period is almost wholly on the transfer of copyhold tenancies. As mentioned earlier, the 1650s are years for which the court leet sittings, those which handled instances of failure to keep to the customs of the manor, are absent. We're left with the court baron sittings, whose business was transfer of tenancy, with a little probate thrown in from time to time. To make a brief digression, there's an opportunity here for mentioning another principle of paleography at this point. If a document is proving awkward to read, one of the best things you can do is to find another example of the same sort of thing in a different, and with any luck, clearer hand. It doesn't even need to be from the same era. This page of the court record from 1743 shows a sitting that begins with a typical resignation and re-grant of a tenancy, of very much the same type as that shown in the previous slide. Reading the later entry is scarcely a matter of paleography. This, with few exceptions, is a modern hand that poses little difficulty to the 21st century reader. Manor courts in general, and Conisborough's was no exception, continued in the 17th century to follow the same basic pattern as they always had. The Lord Steward, presiding over the court, would start by empanelling a jury from all those expected to attend the court. Those attending were those who held or leased property on terms and conditions that included suit of court. That is to say, they were expected to attend the court at every sitting unless they had an excuse or essoin, or had come to a financial arrangement to exempt them from attendance. Otherwise, they would be fined for non-attendance. The court sittings were supposed to be every 3 weeks, but the reduction in the amount of business coming before the court by the mid-17th century meant this was no longer strictly necessary. The cast of characters, or dramatis personae, of the Manor Court was like this. First of all, there was the lord, or lady, if she were the lady in her own right and not simply the lord's wife. This was the landowner, holding the lordship directly from the crown. Rents made up the greater part of his income, but the fines and other payments that came his way from the Manor Court made a significant contribution. He also had land of his own, known as the Lord's Domain, within the manor, and he was able to exploit this land to his own profit in whatever way he thought fit. The court was his court, and he was entitled to preside over it if he wished. The steward was the Lord's representative in the manor. It seems doubtful whether Conisbrough was ever the main residence of its lords. In fact, it seems that since the De Warrens had died out in the 14th century, its lords had barely, if ever, even visited the lordship. In view of this, the steward invariably presided over the court and acted as judge in place of the lord, imposing fines and instructing the bailiff to serve summons, and so on. On the Lord's behalf, he accepted and handed out lands that tenants wished to transfer to others. If necessary, the steward could appoint a deputy to preside at the court in his place. The bailiff was the officer of the court who would collect the customary payments and fines. He was also responsible for summoning alleged wrongdoers to court and for compelling them to attend, either through distraint, which was the seizing of items of movable property, or occasionally by arresting the alleged wrongdoers. There were other officers, but sadly they make no appearance in the court records we're focusing on. The three home townships of Conisbrough, Clifton and Braithwell were overseen by elected officials called graves. These were the equivalent of the officers known as reeves in more southerly parts of the country. The graves carried out the bailiff's instructions in these townships and collected fines and other customary payments. In addition, every township elected a constable who would attend the two courts leet of the year to present breaches of the custom and practice of the manor and more general wrongdoing. The absence of the court leet record for this period and the limited range of business being handled by the court baron by the 1650s mean that we don't get to see either graves or constables in action. The tenants were the occupants of the manor, who could range in social standing from lord to peasant. Some were freeholders, but most were copyholders, and the majority of copyholders were peasants, who worked their allotted plots of land in the open fields and grazed their beasts on the common land. They produced enough to supply their own needs and could sell any surplus in local markets. Copyholders who didn't work the land for themselves could sublet it or employ labourers to work it. The labourers might come from among other copyholders or from another class of peasant, the cottager, who did not have arable land in the open fields, but only their plots of land adjacent to their cottages. These were very much subsistence farmers, able to do little more than feed themselves and their families. Cottagers wouldn't normally hold the land by suit of court, and so are rarely encountered in the manor court record. Tenants holding by suit of court were expected to attend every court sitting, and from the tenants the 12 members of the jury would be chosen. To digress briefly once again, it's perhaps as well to mention one aspect of the custom of the manor that the rolls of the 1650s don't spell out, since this feature does get mentioned at a later date and you might be interested in looking at the record as kept in the 18th century, for example. In order to effect the transfer of a tenancy, the copyholder would hand over a straw as a sign of his or her resignation, or, to use the correct terminology, the surrender of the tenancy. By this act, the tenancy was surrendered into the lord's hands with the express intention that it be granted to another individual. In practice, of course, the straw was in fact handed to the steward as the lord's representative. This had traditionally been done at a court session, but as we see in this instance, it could take place out of court. In the above example, we see that Benjamin Amory, gentleman, did, by the hands of Francis Armitage, by a straw, surrender into the hands of the lord of the manor all that 1 yard of land in Clifton. Straw and surrender don't belong to each other in this passage. It's did, by a straw, surrender, but the custom has been to refer to these events as straw surrenders simply because the two words are next to each other. Note, incidentally, that Benjamin Amory had not only effected the surrender out of court, but that he'd done it through a representative, one Francis Armitage. Later on, this resignation would be copied onto a separate piece of parchment, and the straw would be threaded through the copy. The copy of the court roll with straw would then be handed to the grantee as his or her title to the tenancy, hence the expression copyhold. This form of surrender had been customary for 150 years or so, but was not normally referred to in the court rolls until rather later. This extract is from 1771. We'll now go through a court sitting in a little detail. The record of a court sitting always begins with the dating clause. This example tells us that the court baron was held at Conisbrough on the 7th of July 1657 before Edmund Nicholson, gentleman, steward there. This paragraph starts off by listing the 12 members of the jury. They were also known as the homage or homagers. indicating that they'd done homage to the Lord, that is, sworn an oath of fealty or loyalty to him, and they've also been sworn in as jurors. The list of the 12 jurors points us towards another principle of palaeography, namely that personal names, providing you can recognise them, even if a little different from their modern versions, are a good source of capital letters and combinations of letters that can be compared with and shed light on unexpected and puzzling letter forms in the body of the text. Place names are similarly helpful for this purpose. The jurors are seen to have been conducting an inquisition. You'll see this from the next to the last word of the 6th line of this paragraph. And specifically, conducting an inquisition post-mortem. Now this shouldn't be confused with a modern inquest. It's not concerned with the cause of death, it's concerned with the property held by the deceased at the time of their death, and with identifying the heirs to the property. Here, the jurors are presenting on their oaths that Marjorie Morton, widow, late of Conisbrough, deceased, in her lifetime, was seized, had actual possession, that is, of something for the term of her life. Unfortunately, the clerk has missed at least one line when copying out the text, and we're left in the dark as to precisely what Marjorie held. We know that she was the widow of Thomas Morton, and that she'd been in possession of these unnamed premises about the 23 day of May, preceding the date of this inquest. We can assume that this is the date on which Marjorie is believed to have died. The jurors also find that Elizabeth and Anne Morton, daughters of Thomas and Marjorie, are the co-heirs to the premises. They're both found to be 1 and 20 years old, which doesn't mean, incidentally, that they're both exactly 21, but that they're both of full age and can therefore inherit the tenancy. The jury presents that the land is held of the lord of the manor in free and common socage, fealty, suit of court, and for a yearly rent of 1 penny. Elizabeth and Anne come into the court and pay a penny in relief, which is a fine equal to a year's rent paid for admission to the tenancy. This is paid to the bailiff, they do fealty to the lord, and so they successfully inherit their late mother's property. Here's the second piece of business to come before the court at this sitting. It starts with a minor clerical error. The word court is repeated so that it reads at this court. At the court, Thomas Vincent Esquire, that is, a man of a little higher social status than a gentleman, in his proper person, meaning that he sent no one to act on his behalf, surrenders, firstly, a messuage with tenement in Conisbrough, messuage in this context usually signifying copyhold tenure, and it's occupied by Richard Dickinson. And secondly, he resigns a cottage and tenement occupied by Christopher Lambert. He's resigning these things for the use and behoof of his eldest daughter Susanna, a spinster, and to her heirs. Susanna comes into the court and asks to be admitted to the tenancy, pays her fine, does her fealty, and is admitted accordingly. In the third piece of business, Richard Nicholson of Conisbrough comes into the court and surrenders 7 yards in length and 4 feet in breadth of land in Conisbrough now builded upon, which was part of an orchard. It lies on the north side of the orchard. He surrenders this to the use and behoof of John Vincent Esquire. John comes into court, asks to be admitted as tenant, pays his fine, does his fealty, and is admitted as tenant. I'm now going to leave it to you to read through another entry in the record. This is from the fair copy, written out from the notes made at the time of the court sitting, and so I hope it won't prove too difficult. You can zoom in on the full text in the previous slide if you like, but we've broken up the text into sections to give that extra degree of clarity. Here's the opening paragraph. Moving into the second paragraph, here are its first 13 lines. Following on are the next 21 lines. You'll see that the court and the clerk are being made to do quite a bit of work to deal with this piece of conveyancing. These are the final 20 lines that bring the record of this particular, fairly involved case to a close. Here's the same set of slides, this time with a précis of their contents. The first paragraph starts by naming the Lord of the Manor, the Right Honourable Sir John Carey, Knight, Viscount Rochford. It goes on to give the date of the court sitting as 7th of July 1657, and tells us that the court was held before the steward, Edmund Nicholson, gentleman. The second paragraph starts by telling us that the jurors present on their oaths that Robert Nicholson of Clifton, yeoman, leased to William Amery of Conisbrough, yeoman, by an indenture dated the 4th of July 1657, a messuage in Clifton, and 9 acres and half a rood of land in Clifton and Conisbrough, and that he had done this without paying a fine to the Lord and without the Lord's licence, and that this was against the custom of the manor. A yeoman, by the way, was usually a holder of freehold land, but who was below the rank of gentleman. He was reckoned to be a yeoman by virtue of the total value of his land holdings, perhaps also including leasehold and copyhold, which would be 40 shillings or more. This lease was to have been for a period of 5 years, beginning on the 10th of June 1657, for a rent of 6pence a year. Because the lease was unlicensed, though, the land was forfeited to the Lord by Robert Nicholson, and the court commanded the bailiff, Thomas Gill, to seize the tenements in question and answer to the Lord for the issues, that is, the rents and other profits from the tenements, and to certify the steward that he'd done so. The bailiff duly certified that he'd seized the tenement as instructed. Whether the bailiff had completed his task of seizing the tenements in time to report to the court on the same day, 7th of July, seems doubtful, and Thomas Gill's certification may date from the court session on the following 25th of August, which is reported on in the same long paragraph. On that date, the court made a proclamation requiring anyone claiming to hold these tenements of the Lord of the Manor to come and be received. However, nobody offered to claim the tenements. The same proclamation was made a second time at the court held on 15th of September. The second proclamation had the same result, and the same proclamation was made again at the court session of 26th of October. This had the same result as the previous proclamations. The court had no claimant except for Robert Nicholson. The steward granted the tenements to Nicholson to be held at the Lord's will by the same ancient rents and services. Nicholson then pays a fine to enter the tenement and asks to be admitted to it. On the Lord's instruction, the steward gives seizin of the tenements to Nicholson and admits him to the tenements. And so we're back to where we started, before the unlicensed lease to William Amery. We're now going to give you the opportunity to try your hand at a more cursive style of writing, the sort used for the draft of the court record here, and the sort that's more typical of handwriting in general at this period. Images of 2 leaves from the record, the back or verso of one and the front or recto of the other, are on this and the next slide. The text from either leaf is split into 2, top and bottom, so as to give a bigger and clearer image. Here's the first page, which starts with the last 8 lines of one entry and goes on to the first 25 lines of the next entry. This second entry, numbered 31 as you'll see, runs on to the next page where it concludes. See if you can write out a transcript of the complete entry, or produce a précis of the event described if you prefer. On the recto of the second page we have the concluding 15 lines of the complete entry that I suggested you might like to transcribe or summarise. The image of the bottom half of the page shows the opening 19 lines of the following entry, numbered 32. Just in case you found any of this text at all obscure, we now have the same 4 images of the record alongside a transcription of each section. The transcript is the work of 2 volunteers or credited at the end of the session. The transcript reproduces capitals, punctuation, crossings out and spellings as they appear in the original. Abbreviations are expanded inside square brackets, and insertions between backward and forward leaning oblique strokes. The obsolete letter thorn, which we looked at in session 2, is also used where it appears in the original. The date of each court session has been inserted between entries in square brackets. Entry 31 continues on this slide with the swearing in of the jurors and their statement about the tenement of the late Margaret Stables. This entry now concludes with the identification of the heirs to Margaret's tenement and the granting of seizin to one of them, namely Sarah, wife of William Glue. The second page goes on to cover the opening part of a surrender and re-grant of a tenancy, which is transcribed here for the sake of completeness. If you're interested in looking at the conclusion of this entry, or indeed any other part of the English language section of the Conisbrough Rolls from the 1650s, images of the record will be available online in due course. This won't happen straight away, since, as you can tell from the dog-earing and other damage in these 2 pages, the record for this period will need to be conserved before it can be digitised properly. As soon as these images can be viewed, though, we shall let you know via the Conisbrough Court Rolls website. Thank you for completing this short course. We've looked at some of the background to the Conisbrough Manor Court records and gone on to examine letter formation, abbreviation, spellings, numerals, court terminology and the nature of court business. We hope that from this use of a decade's worth of the Conisbrough Court Rolls as a source text, you'll have gained something of an understanding of palaeography, and that you'll make use of the skills you picked up to help you in interpreting other historical documents and become increasingly confident in reading a much wider range of material than that found in a 10-year period in one part of South Yorkshire. This course was made possible by an award from the National Lottery Heritage Fund and a generous grant from the Friends of the National Libraries. This funding allowed us to devise an exciting project that began with the purchase of the Conisbrough Manor Court Rolls. More information can be found out about the project on our website that will be linked in the description box below.